Good evening. This is John Milburn for Laws 11059, Statutory Interpretation. This is week 9. We're dealing with issues to do with the way in which the common law still applies in statutory interpretation and how it fits in with the role of statutes which deal with statutory interpretation. Before we do that, there is a theme that I want to advance tonight, and that is the way in which you can use materials that are available to you on the web, partly as a valuable resource, but partly also as a valuable learning resource. So can I ask this, is anyone familiar with the Queensland Legislation Handbook? Can I just show of hands? We're familiar with that one, the Queensland Legislation Handbook? All right. Well, look, let's have a look at that first up tonight. I'm going to share the screen. And hopefully the link that I've created will work. And I'm just doing that now. This is to the Queensland Legislation Handbook. And I'll put that on the second screen. You should see that now. All right. So this is a terrific resource. And I think it's extremely valuable for a couple of reasons. The first is that it provides you with an opportunity to consider what those people who are creating the laws consider. It's an opportunity for you to learn, and it's also a very powerful tool to use at your disposal when you're making or mounting an argument. All right, so let's go back to basics. In terms of Queensland legislation, we know, of course, that it has power to do things that are residual to that power which is conferred upon the Commonwealth. So the Australian Constitution, of course, provides the Commonwealth Parliament with the ability to make laws about a particular list of matters, but also in relation to another list, which is Section 51. The Commonwealth has power to make laws which can also be shared with the states. And we all know, of course, that if there is a law of the Commonwealth and the state, then the Commonwealth law will apply. And I'll just get you to mute your microphone there if you're just joining us. But feel free, of course, to unmute your microphone if you wish to ask a question or make a comment. All right, so the Queensland Legislation Handbook governing Queensland is extensive and very valuable resource. So you'll see from the index a number of things that we've talked about in general terms during this course, and some things that perhaps that we haven't. You'll also see reference to legislation, and you will see reference to other bodies that have relevance in terms of statutory interpretation. So the Office of the Queensland Parliamentary Council, for example. Subordinate legislation we've talked about, and there is at the end an appendix dealing with the making of legislation. Now, I'm just going to highlight a few things here, but I would urge you to not necessarily read all of this, but certainly to consider it and supplement what you've already read. And when you do look at it, think of it as something that you can use when you need to mount an argument which is based on legislative process and statutory interpretation. Let's have a look at, for example, 2.11.16. So that's other matters needing consideration through policy development. And there may be a quick way for me to get to this, but I haven't learned how to do that yet. All right, so liability of directors or executive officers of corporation for corporation offences. So what we see there is that it's possible for directors to be held liable for the offences of the company that they represent. And you'll see policy guidelines that propose legislation should not make them personally liable for offences unless there is clear justification for doing so. Now, the reason I point to that clause is in the context of statutory interpretation, a valuable tool for you to consider if you're ever in a situation of advising a director or executive officer charged with a criminal offence based on what the company has done. So it's just an example, but it's something that goes to the manner in which the legislation in question should be considered. It's also a valuable example because it highlights the fact that from time to time, you may need to consider outside agencies. For example, here there's a direct reference to the Directors' Liability Principles published by the Council of Australian Governments, or COAG. So it gives you an opportunity to consider other sources where you may find something that can assist you. And you'll see that the Directors' Liability Principle is published by COAG, and it should be considered in deciding if the imposition of this kind of liability, derivative liability, is justifiable in the particular circumstances. If you have any questions, please feel free to unmute your microphone and ask, or use the chat facility. Alan, do you wish to make a note? No? I'm just looking to see if anyone's online. I can just hear someone, that's all. Ernest, is that you? No? All right. Let's have a look at paragraph 3, which deals with the drafting process. So we've talked about the way in which laws come into being. What we haven't specifically done is talk about where you might go to consider the specifics of the drafting process. Well, here it is. So this chapter considers the drafting process from the perspective of the Office of Queensland Parliamentary Council's involvement. So that office may be involved in the drafting process before an authority to prepare a bill submission is approved by Cabinet. However, the formal drafting process occurs when Cabinet authority to prepare the bill is approved and drafting instructions are sent through to the Office of the Queensland Parliamentary Council. So I think in the earlier session there was a question about who prepares some of these things. So I think that might have been you, Alan. This is where I would start to look in terms of deciding who has been responsible for actually drafting certain materials. Okay, let's have a look at 3.5.2, and I'm just really selecting examples of what I think is important in this document. You may think that there are other things that are equally, if not more important than what I'm highlighting. So 3.5.2, you'll see on the right-hand side there, deals with acts of general application, and you'll see a reference to 3 pieces of legislation, all relevant in terms of statutory interpretation. The Acts Interpretation Act, 1954, Queensland, of course, or Queensland, the Statutory Instruments Act of 1992, and the Legislative Standards Act of 1992. So we've talked about the Acts Interpretation Act, but we really haven't talked about the other 2. So by referring to this handbook, it tells me that all 3 pieces of legislation have a role to play in terms of statutory interpretation. It also provides a bit of background. The Acts Interpretation Act was originally known as the Acts Shortening Act. The Statutory Interpretations Act clarifies the law about statutory instruments, particularly in relation to the power to make those instruments, and it also defines the term statutory instrument, which includes subordinate legislation. And the Legislative Standards Act establishes the Office of the Queensland Parliamentary Council as an independent statutory office and outlines its function and the fundamental legislative principles. Again, if there's any questions, please feel free to ask. Another thing that I think is important is 3.7.2, which might look a bit familiar because we're now talking about explanatory notes. And in that commentary, you'll see that it is the department usually the instructing officer who's responsible for preparing the accompanying documents required for the introduction of a bill, such as the explanatory notes and the minister's parliamentary explanatory speech. So it gives you an idea of where these things come from. And under the Legislative Standards Act 1992, Section 22, the minister who presents the bill must circulate those notes to the bill. Another thing that we've talked about during this course is the second reading. And this document at 4.8 provides a bit more commentary in relation to what's meant by the second reading and how it fits into the scheme of things. The second reading provides important detail about the requirements. This commentary provides important detail about the requirements for the second reading. And you'll see that there's reference to the standing rules, the orders of the Legislative Assembly, and the Queensland Parliamentary Procedures Handbook. So again, we have a hint as to other things that might be relevant when considering statutory interpretation. And also it provides some detail as to what's intended during the second reading speech, and that is debate, which is a free-ranging debate and may address the principles of the bills. That's why the second reading is important in the context of the life of a bill. I won't labour over this too much longer because I hope that you'll have a look at this for yourself, but you'll see Part 5 deals with royal assent, and it talks about the actual responsibility of the Clerk of the Parliament to advise the Office of the Queensland Parliamentary Council of the details of the assent and request the Parliamentary Council prepare a copy of the Act. So it provides some of the mechanisms so you can actually see what happens behind the scenes. It also refers to the Queensland Parliamentary Procedures Handbook, and noting that the process of having a bill assented can take up to 2 weeks. Part 6 deals with subordinate legislation that we've talked about, and that is often referred to as legislative instruments made by an entity under a power delegated to that entity by Parliament. And you'll see there a statement about why we do delegate legislation. We've talked about that before. And this is an interesting part, and it's something that you might want to keep up your sleeve if you're going to mount an argument, and that is you can't necessarily assume that the delegation has been lawfully conducted. It may be that you can argue that there has been an unauthorised delegation or unauthorised subdelegation. In other words, it may be that the party that purported to make subordinate legislation did so in circumstances where it acted beyond its authority, or it acted, as we call it, ultra vires. And that's something that you might consider. Look, it might be regarded as a very technical argument, but it's important because if your client is charged with breaching some subordinate legislation prepared under delegation or subdelegation, to do your job properly, you need to check whether in fact the delegation or the subdelegation was done lawfully and the subordinate legislation was prepared in accordance with that power. 6.11 deals with explanatory notes. It refers to the Legislative Standards Act. 6.13 deals with tabling and disallowance, and again we see reference to other legislation, that is the Statutory Instruments Act. Have a look at Section 7, which deals with fundamental legislative principles. Now this could be useful depending on the nature of the argument that you wish to advance. And 7.13, for example, deals with the principle of legality in terms of modifying or abrogating fundamental legislative principles. And it's got a really good commentary here in terms of the way in which the High Court interprets statutory provisions in such a way as not to modify or abrogate important common law rights, freedoms, privileges, or immunities in the absence of clear words or necessary implication. It then goes on to identify with a list the type of common law rights, freedoms, privileges and immunities that are protected by the rule, including, for example, freedom of movement, freedom of speech. So if you have a statutory interpretation question and you believe that the legislation purports to restrict a person's capacity to enjoy their common law rights or freedoms or privileges or immunities, then referring to this document gives you greater persuasive value in terms of arguing your position. There's also a reference to X7 against the Australian Crime Commission from 2013, which is a very handy authority. Okay, I know I'm doing a lot of talking, but you get the idea that this is a valuable document to consider. Read it for the knowledge that you'll gain from it, but keep it in mind for the way in which it might assist you when you're mounting an argument. Are there any questions so far? All good? Okay. I'll just show you one more thing. Sorry. Sorry while I die here. Look at. Have a look at that appendix for a moment. Okay, so there we'll see a valuable flowchart that you might want to consider using or referring to. It also provides a good example of the sort of ingenuity that I'm encouraging you to consider in your assessment work as a way of demonstrating a concept using flowcharts. All right, now what I want to next do is refer you to the Office of the Queensland Parliamentary Council. Has anyone heard of that website? Office of the Parliamentary Council? Yes, Angelina? Can't hear there, Angelina. No, still can't hear you, sorry. That's okay. We'll work out those technical issues. Does anyone else wish to say anything about the Office of the Queensland Parliamentary Council, what it is, what it does? All right. Let's I just want to show you this new website for it. You may have come across this already. It's live now. I'll share the screen again in order to do that. You should now see the new website, which you'll see is under construction for the Office of the Queensland Parliamentary Council, which provides you with an opportunity to consider Queensland legislation. It's a good website. I just started to play around with this and get an idea of what's in it. And you'll see, for example, that we have acts as passed, a different layout for that legislation, and very user-friendly. So if we just choose one of those pieces of legislation, say, for example, the Child Protection Act, a lot of the links aren't yet working, so just bear that in mind. That's not a good example because it's not as well developed yet as it will be. Let's see if I can get to the Civil Liability Act is what I had in mind. See, there's a lot of acts. And a lot of you will be looking at me saying, I know how to get around these things much better. All right, so we have the legislation. We have an opportunity to consider it by using links, which we wouldn't have seen in previous iterations of websites. It also has information about legislative tables, but that's under construction, notification, information, and historical information could be useful if you're arguing something. So there's not a lot on that one yet, but it's certainly getting there, and it will be replaced completely by mid-2017. Now at a federal level, the counterpart is the Federal Register of Legislation, and that's the authorised whole of government website for Commonwealth legislation, and it's maintained by the Office of the Parliamentary Counsel at a Commonwealth level. Okay, and it also includes a useful little resource, which is the A to Z of key jargon. Those of you that have been looking at these websites may well have found some of these things, and you may have found things that you find more valuable than what I'm showing you. But the intention I have is to ensure that you do follow up and look at these sorts of opportunities. Okay, I'll stop the share of the screen now so that we can now talk about Chapter 9. So Angelina said used for plain drafting of a bill, but it may have been the Commonwealth. Yep. So there are the plain drafting guidelines, which are referred to there as well. Okay, now the reading this week I think was a bit dry, but we're dealing with this week what would normally be Chapter 1 of a text. Now the reason I say that is that typically the way in which statutory interpretation is taught is that we start with the literal rule, the golden rule, and the mischief rule. Now I did do that. The author of the text, Sanson, says don't do that, bring the common law in later. And the reason for that is that otherwise people will think that the common law rules are the primary rules. And of course, the fact is with parliamentary sovereignty and the rise of legislation, that it is the legislation that must be considered first rather than the common law rules. Common law rules, of course, are rules that are made by the courts, and that's what we mean by the common law. Okay, in the text, you would have read about Brennan and against Comcare from 1994, and I just want to refer you to the statement of Justice Gummow, who said that when you're considering applying statutory interpretation rules, it is different to the doctrine of precedent, which is more widely used, and essentially His Honour was saying that you'd only apply statutory interpretation from one case to the next if it directly applied and the facts directly aligned with the previous facts, which is probably unlikely. The other thing is in Jaeger against the Crown, Justice Mason confirmed that the construction of statutes is a question of law. Now, the authors have made a really good point here in the sense that if you have a jury trial, and for example, there might be an issue about the word consent. For those of you that did Introduction to Law, I've shown you the bench books. And there may be a bench book that deals with the issue of how the concept or word of consent is explained by a judge to a jury. But the point that we take from Jaeger's case is that when it comes to deciding the way in which statutes are constructed and the words within those statutes, that's a question of law. And as we know, in a criminal law context, questions of law are determined by the judge and questions of fact are determined by the jury. So to take that example of the word consent, it's up to the jury to determine whether there was or was not consent, but to do so by applying the way in which the word is legally interpreted through statements made by the judge. I hope that makes some sense. And again, if there's any questions or comments, please feel free to jump in. Okay. If you've got your textbook there, and of course I'm talking about statutory interpretation by Sanson, I'm going to ask you to have a look at the figure 9.1 on page 202 of your text. I thought it was quite useful way of describing what might otherwise be a difficult concept. And the author has described the interaction between the common law and the statute in the development of law in different ways. And you'll see that the common law has a place to play in all of those scenarios except the second one. In the second one, we have a situation where the statute is passed in circumstances where it purports to cover the field and replace the common law. Now, sometimes, this is scenario 3, new laws create statutory rights that didn't previously exist, and that means that that covers it. But in scenario 3, it also includes material that is subject to the common law. Now, in Introduction to Law, you'll recall we discussed legal reasoning. We discussed reasoning by analogy, for example, and that's referred to, legal reasoning principles are referred to in scenarios D, E, and F. So scenario D is where the common law is developed through reasoning by analogy to statutory principles. And the interesting case there is that case of R against L. It's High Court 1991, and it deals with that issue of whether or not a person can be charged with rape in a marriage situation. And the lawyers for the defence, I think, were really inventive in the way that they put forward their defence. It was ultimately unsuccessful, of course. But in defence to a charge of rape, the husband said it is a common law obligation for his wife to have sexual intercourse with him. In mounting that argument, he referred to section 114 of the Family Law Act, which is the Commonwealth, and he looked at the way in which that section was worded, because it said that the court, the Family Law Court, or Federal Circuit Court, may make an order relieving a party to a marriage from any obligation to perform marital services or render conjugal rights, and said, by implication, that legislation says that parties to a marriage do have an obligation to perform marital services or render conjugal rights, and therefore argued that it was inherent in that Commonwealth legislation that the spouse had to perform those obligations, and pursuant to section 109 of the Constitution, the Commonwealth provision should prevail over the state provision to the extent of any inconsistency. So that was the argument in R against L. It was unsuccessful, and if it wasn't successful, it would have been overturned by legislation. But it was an inventive argument. Creative solicitor, yeah. Okay, have a look at page 205. And at page 205, the author talks about the ongoing challenge with the analogous use of statutes and the fact that we do have 9 separate legislatures, each with power to enact statutes, and they can mark differently. So we have the states, the territories, and the Commonwealth. So while we may have one common law, we have potentially 9 statutory parliaments that can make powers and laws. So the author talks about that issue and does so in the context of Baker against the Crown, 2012 High Court, and the full court of the High Court refused to use the Uniform Evidence Act to adapt the common law principles of evidence in circumstances where in Queensland and other states they hadn't adopted that Uniform Evidence Act. Those of you doing evidence next year, I'm taking that subject evidence and proof. Okay, so scenario deals with the example of the analogous legislation in coming to its decision. Okay, it's only then that the author gets to what most textbooks start with, which is our good old friends, the literal rule, the golden rule, and the mischief rule. I'm not going to ask you again what they mean. I'm sure we all know that. And if you don't know what those rules mean, please go and have a look now at some stage soon. What I would like to do is now turn to problem 16, which is at page 216 of your text. And for those of you that have proffered an answer or a comment in relation to the problem on Moodle, I thank you very much. And we'll go to Moodle. So if you have some thoughts in relation to problem 16, which is based on the case of Field against Gent. I say Gent, I mean, I don't know, maybe it is Gent, I don't know. But I say Gent. Then I'll be looking for your thoughts in relation to it. So I'll now share the screen. We'll have a look at who's provided a response. I'll thank you again for doing so. And problem 16. We have Vivian, Shireen, Alan, and Monique. Okay, so this was the case about the throwing of petrol, yes? Would anyone like to tell me something about what this case was about and what the court considered as being relevant? Who'd like to go first?
Johnny, I'll go.
Yeah, thanks, Leonie.
All right, so it was about two 10-year-old kids, and they'd been left outside with an open fire, and they had made the joint decision to rekindle the fire. So they found a petrol can, and they were dipping sticks, and then they carried over a cup of it. In the end, there were a he said, she said situation with no witnesses, and the young girl got burnt. So the case was about not how she got burnt, but whether or not the way in which she was burnt. So whether the liquid in the cup could have been considered a missile, using the ordinary meaning of the words, and whether or not his behaviour had led to her being able to claim compensation as a victim in the ordinary sense of the offence legislation that they were using for South Australia. So I think two judges found that after they went through all the dictionary meanings that yes, the liquid in the cup could have been considered a missile. And then one of them was dissenting, and I can't remember his name. He said that the liquid in the cup is not considered a missile. It's the actual container itself, it's the missile. So that's where he was sort of differentiating, I suppose, from the other two. So that was one issue. There was a little bit more, but I can't remember the rest of it. Sorry.
No, that's good. Thanks very much, Leonie. Does anyone else wish to make any comments about that case or provide some feedback in relation to Leonie's response?
Yes, John.
Yes, Shireen.
Yeah, when I was reading through it, I don't know, I just thought that it was unusual how they was 3 years on, and whether I think I mentioned it in my comments when I responded, is that if an interview had have taken place when he was 10, it would have been difficult for the police to establish whether he had the capacity or not to understand that what he was doing was not right, as opposed to when he was 13. I think they established then the father, I think I highlighted the text in relation to that. The father said that he knew what he was doing because he'd seen bonfires, etc. And I was just sort of wondering about how that would all sort of come to be fair, in the whole situation. I was wondering about that.
Okay, no, thank you, Shireen. I appreciate that. Now, does anyone else have any thoughts or comments in relation to that case? Appreciate your contributions both online and tonight. All right. My view is I found it a surprising case in the sense of the final conclusion. I do like the way in which Sanson writes the material, outlining the position and then asking you to stop and consider and provide an answer before reading on. And while I have got the right answer most of the times, this is one where I got the wrong answer. In other words, I was of the view that the alternate position was the better view. I had difficulty in this case for a couple of reasons. One is the issue of criminality and capacity, which I think, Leonie, you talked about, and also the issue of whether this was a missile. I couldn't reconcile it, so I had some difficulties there as well. And that's okay. You can always disagree with the conclusions, provided, of course, you do so respectfully. But, of course, once the law is made, that becomes the law and you must follow it, even though you may not agree with it. Now, does anyone wish to make any comments about what Shireen or Leonie or I have said about this case, Field and Gent? So, Angelina, yes? Sorry?
John, I just wanted to ask a question. Now, part of what Sanson had talked about was that, I'm not even going to try and say the Latin word for it. Anyway, EJUSDEM. Yeah, I haven't. Anyway, they were trying to figure out whether it could extend, couldn't it, to the section 51 of that act. Is that correct?
That's correct. Absolutely correct. Yep.
So I was reading through it, and I was having trouble with both section 1 and section 2, when it actually went to the definition and said firearm means gun or device, including an air gun from or by which any kind of shot, bullet or missile can be discharged. But yet in section 1 it says a person who discharges a firearm or throws a stone or any other or other missile. They all said it couldn't extend to that. Is that correct? Because of that one phrase, throws a stone?
Yep.
I was having trouble with that because I didn't understand if throw was to discharge or project by means of any mechanism or device, then the cup would be covered under it, wouldn't it? But they said it couldn't because of the word stone was preceding.
There was that issue, and there was the issue of determining, I guess in simple terms, whether the fuel was regarded as a missile. And I struggled with that, but the majority said it was, is the way I got that case.
I got the alternate as well. I had no idea, but I just thought maybe you could have just enlightened me on how they came to be, because I didn't understand how they got that it was a missile, but I suppose Sanson had put it quite, explained it quite easily that it was in a container, therefore it was a missile. But I just couldn't, if you were looking at the legislation, I couldn't understand the actual legislation to be able to extend to that Latin word, that was all.
I think when I read it, I wondered what the High Court might make of this case had it gone to the High Court. And I'm thinking of other somewhat similar cases like CIC and Insurance in Bankstown Football Club, and others where the High Court have overturned the full court's decisions in certain areas. I think the full court was looking to find a way to compensate in circumstances where they had to stretch and broaden the interpretation. My personal view is that they probably went too far in that regard, but it is quite a broad interpretation. So Chris said, if you throw it, it must be a missile. Yep, so that's an argument. Monique struggled with the question. Angelina takes a different view and says, well, maybe it was the fire that caused the injury, not the fuel. So that's another way of looking at it that I hadn't considered. Vivian had trouble finding that case online, which I must confess I didn't look for the original decision. So did anyone find the case online?
like Vivian, I couldn't find it at all. But I also note that the Act seems to be quite different from what's quoted in Sanson. Section 51 is very different. So there must have been an amendment. I was only guessing on what was going on in my response.
Yep. So I guess what we've identified is that we don't necessarily have all the information, or it may have been that the Sanson has adopted a different approach to extracting the material than might otherwise have been the case, for example, with you, Alan, looking at different parts of the legislation. Shireen says you can find it on Westlaw. Leonie says the same thing. And Vivian, you might just look at that again. Okay. And also the reasonable cause argument, Monique says, should have been considered. And Shireen offers that there may have been media pressure impacting upon the decision. So I think some of those things may have been relevant. Okay, well, thank you very much for those that contributed a response to problem 16. Problem 17 is also from the text, and this is for those of you with the text at page 220, and it's the decision of Gideon against Commissioner of the New South Wales Crime Commission. It's High Court 2008. Now, we'll just share the screen. If I can find the share button, we'll go to week 9 and we'll look at problem 17. So thank you to, I think there's only 2 have provided a response. 3 have provided a response. Thank you very much for doing so. Okay, so does anyone want to tell me what this case of Gideon's all about? And I'll stop the share now. So what was Gideon all about?
John, yeah.
Thanks, Shireen.
I think I have a bit of, I think I have a bit of an idea. It's in relation to drugs being imported. It was a controlled, I can't remember the word, a controlled something. It was an undercover operation, anyhow, with the New South Wales Police. And in that, during that undercover operation, they had the use of cocaine, which they were importing, and in the end, they ended up charging for a Commonwealth offence. And then when it came to court, the defence brought up the idea that the evidence, which was the cocaine, was unlawfully obtained because it was for that controlled operation. And I can't remember what the result was of it. I think it was overridden in the end, but it was, that was about to do with unlawful drugs and Commonwealth and New South Wales, different statutes, etc.
Thanks, Shireen.
Okay.
And Leonie said yes, controlled operations, and Chris said drugs. So thank you, Shireen and Leonie and Chris. Does anyone else want to tell me something about this case and how it's relevant to statutory interpretation?
Were they trying to figure out whether the actual setting up of the operation and allowing it to continue was valid as a controlled operation, because the end result was going to be that the drugs were going to end up on the street, therefore endangering, which was against this certain section of the legislation. Because the end users were going to get a hold of all these thousands and thousands of packets of cocaine, then it should never have been agreed to in the first place. And they were trying to figure out the any other person part of that statute.
That was relevant, yes. Thanks, Vivian. And then we'll go to Vivian first and then Alan.
Okay, like when there were some of the judges who said that the word any other person, okay, those of them who said the sting operation was valid, we're looking at it in terms of the participants being the police and the law enforcement agents. But the other group that said no, the sting operation was invalid, we're looking at it as the endpoint. So they're looking at any other person, including the end consumers of that dangerous substance. And so, because the intention of Parliament from common sense they would have meant that to protect everybody in the community from that dangerous substance.
Yep. No, thank you for your input there, Vivian. I appreciate that. Alan?
There was evidence that the Commissioner knew in advance that between 70,000 and 100,000 doses of cocaine would be in the market. And it was on the strength of that, the interpretation was that a reasonable person in the Commissioner's position would actually foresee that there could be some harms from that. And therefore, that triggered the section 7(1)(b), which makes the controlled operation invalid.
Okay. So we're all along the right lines here, that we're talking about the way in which the court interpreted this controlled operation and had to consider the risk to the end producers or purchasers of the cocaine. So what did the court ultimately decide? What was the final outcome in the High Court?
I think they overturned the original prosecution.
Yep. So the High Court decided that when talking about any other person, it literally means what it says, which means that the provision did cover end users, and therefore there was no lawful power to conduct the sting operation. So from a defence lawyer's perspective, a long, very long fight, but with a favourable outcome from defence perspective. All right. Look, I propose to wrap it up for tonight. Are there any questions or comments before I do so? Yes, Alan?
Just a thought on that same case. Couldn't it be argued that the Commissioner was empowered to actually make crucial decisions like that, and like no other ordinary person? And an interpretation on that could be that he is in a special position to make those decisions appropriately.
Yeah, I think what it does is this case ties in with an earlier thing that we talked about tonight, and that is delegated powers and the question of ultra vires, and whether the Commissioner had in fact exceeded his or her powers in making the order that he or she did. And I think that the court has basically said that the authority conferred upon the Commissioner pursuant to subsection 1 of section 7 goes so far, but the Commissioner exceeded that power in authorising this sting operation in circumstances where there was the likelihood of loss or damage to or injury to persons as a result of 70 to 100,000 hits or doses, if you like, of cocaine on the streets. Now, that was my take on it anyway. All right. Now, a couple of things. Any general assessment feedback? Not yet, not tonight. Just curious, do we get penalised? No, I won't ask that one. Australia Day next week. We will have a tutorial. So we'll be brave. We'll front up. We'll do that. Okay. Yeah, and so everybody was saying, yeah, pretty sure there will be, and there will be. We can fight on. All right. Well, thank you very much for your participation tonight. Thanks for those of you that are providing responses to the tutorial questions, and we'll see you all next week. So I'll end the meeting now. Oh, just as a quick aside, with Zoom, which I use for recording, there's been an upgrade. I just saw it when I went to record this session. I have a choice whether to save it to my computer or the cloud. I chose one of those, but with Introduction to Law, I didn't see it, and I didn't know why it didn't record, but it just didn't, because I think now I didn't choose one of those, so it said, well, I'm not recording it then if you're not going to choose. So I'll do a mock-up of the Introduction to Law tutorial for those of you that want to view that on Moodle or uCrew. Anyway, that's enough for statutory interpretation. Thank you very much, and we'll see you all next week. Bye.